मैं थोड़ा हरजाप तो हरेक मंडे 7 बजे तुसीं तो मैं आपस में गल्लां करांगे साडी कम्यूनिटी दियां, साडे बच्चों दियां, साडे बाहर रहिंदे NRIयां दियां, साडे देश दियां, तो जो अजकल दे इशू है सानू अफेक्ट करदे उन्हां दियां। So let's talk with Harjap.
we need to look out for? Because, and if we sign it, then are they reasonable and are we bound by them?
Again, a very, very good question. The most important clauses tend to be what they call restrictive covenants. They're the ones that restrict you moving on to do a similar type of role with another competitor who's there locally. Those are the ones that you really, really need to be wary of. So if you're, I don't know, a manager and you work for one rice company and then you move on to, or let's say work for a farm and you move on to another farm, there may be covenants, restrictive covenants they're actually called, that stop you doing that. You have to be aware of what they actually say, because they can be unreasonable as well.
ਜੇ ਮੈਨੂੰ ਕੋਈ ਕੰਮ ਤੇ ਕੁਝ ਕਹਿੰਦਾ ਆ ਮੇਰੇ ਮੈਨੇਜਰ ਕਿ ਤੂੰ ਕੰਮ ਨਹੀਂ ਠੀਕ ਕਰਦਾ ਜਾਂ ਕੀ ਆ and I don't think that's right, ਫਿਰ ਮੈਂ ਕੀ ਕਰ ਸਕਦਾ?
That goes down to the very crux of what they call the grievance procedure.
Right. A grievance procedure ਕੀ ਹੁੰਦਾ ਹੈ?
Grievance procedure is your avenue or your chance to make a complaint. Because when an employer wants to make a complaint, he puts you under the disciplinary procedure, and depending on how bad that is, you can be sacked. But the other side of that is a grievance procedure. It allows you to make a complaint about that manager because you might feel what he's saying is wrong and it affects you, you're distressed by it, you're unhappy and it's affecting you. So you can make a complaint.
What about, well, what is a dismissal? Do you know ਅਸੀਂ ਸੈਕ ਕਹਿੰਦੇ ਆ ਪੰਜਾਬੀ ਤੈਨੂੰ ਸੈਕ ਹੋ ਗਈ ਹੈ ਤੈਨੂੰ ਸੈਕ ਕਰ ਦੇਣੀ ਹੈ ਉਹ ਜਿੱਦਾਂ I think in English ਉਹਨੂੰ dismissal ਸਕਦੇ ਆ in Punjabi we shorten it down to 4 letters sack. You are the sack.
Well, that is basically the termination of your contract and you are no longer an employee. Now it could be sort of gross misconduct,
right?
Where your actions or something that you've done is so bad, like coming to work drunk, or you've hit someone. In some cases, if you start playing cards and gambling, it's gross misconduct. There, they can sack you immediately.
Wow, cards and gambling.
I can't
say the bookies.
There, they'll sack you. Most companies have the same sort of policies. Or you've been sick all the time, or your work isn't up to scratch. So they take you through the disciplinary procedure, and you're just not working, and they sack you.
ਜਦੋਂ ਕਿਸੇ ਨੂੰ ਸੈਕ ਹੁੰਦੀ ਆ ਤਾਂ ਇੱਕਦਮ ਸੈਕ ਜਿੱਦਾਂ ਫਰਜ਼ ਕਰੋ ਹੁਣ ਕੋਈ ਬੰਦਾ ਕੋਈ ਲੇਟ ਆਇਆ ਕੰਮ ਤੇ and ਉਹ ਇਦਾਂ ਨਹੀਂ ਕਹਿ ਸਕਦੇ ਫਿਰ ਤੈਨੂੰ ਸੈਕ ਦਿੱਤੀ ਆ
No.
Can they?
They can. Okay. An employer
can do what he wants, basically.
Can do what he wants. There's no law that says who can or who can't hire or fire. But is a key word. The law says you've got to do it fairly.
Right.
You've got to do it. You don't want someone there. That's fine. And then all the employer does is, right, the reason why I don't want you here is because this, and this. You have to give them a chance, the employee, to fix whatever it is that's wrong.
Listen, India ਚ ਬੰਦੇ ਨੂੰ ਜੌਬ ਤੇ ਦੇਈਦਾ ਅਸੀਂ ਜੌਬ ਤੇ ਰੱਖੀਦਾ ਜੇ ਨਹੀਂ ਵਧੀਆ ਕੰਮ ਤੇ ਦੋ ਛੱਡ ਕੇ ਉਹਨਾਂ ਕਹੇ ਜਾ ਕਰ and ਜਿਹੜਾ ਤੇਰਾ ਹਿਸਾਬ ਕਿਤਾਬ ਹੈ ਲੈ ਲਾ that's what we're used to. ਅਸੀਂ used to it. But ਜੇ ਫਰਜ਼ ਕਰੋ ਤੁਸੀਂ ਕੋਈ ਬੰਦਾ ਰੱਖਿਆ ਐ EMPLOYEE ਰੱਖਿਆ ਤਾਂ ਉਹ ਕੰਮ ਹੀ ਨਹੀਂ ਕਰਦਾ ਅਗਲਾ ਤਾਂ ਕਹੂਗਾ ਮੈਂ ਤਾਂ ਕੰਮ ਹੀ ਨਹੀਂ ਕਰਨਾ ਤੁਸੀਂ ਉੱਥੇ ਸੈਕ ਨਹੀਂ ਦੇ ਸਕਦੇ ਉਹਨੂੰ
No, you can sack them, you just got to do it fairly.
ਸੈਕ ਦੇ ਸਕਦੇ
Yeah, but you just got to do it fairly.
But fairly ਕਰਨਾ ਪੈਂਦਾ.
Yes.
So fairly ਦੇ ਵਿੱਚ ਕਿ ਉਹਨੂੰ ਬੁਲਾ ਕੇ ਫਿਰ ਉਹਨੂੰ ਚਾਹ ਚੂ ਪਿਲਾ ਕੇ what's it mean? ਹੈ ਆ ਚੰਗਾ ਕਾਨੂੰਨ ਹੈ ਇੱਥੇ.
Well, what you've got to say is bring them up and say, look...
you have to point out their faults to them.
Yeah, and then say, right, and then put in a program to say, this is how we're going to correct it. It doesn't have to be long. It can be, depending on the nature of the job, it can be, I don't know, weeks. And you say, right, I'm going to monitor you. And if you don't come up to scratch, because these are the reasons why you're not doing what you're supposed to be doing, we'll have to terminate the contract. And that is your sack.
ਮੈਂ ਸਾਰਿਆਂ ਨੂੰ ਦੱਸਦਾ ਕਿ ਅਸੀਂ sorry for loss of sound earlier. ਚਲੋ ਅਸੀਂ ਤਾਂ ਆਪਣੀ ਗੱਲਾਂ ਫਿਰ ਵੀ ਕੀਤੀਆਂ ਪਰ ਤੁਸੀਂ ਨਹੀਂ ਸੁਣਿਆ ਅਸੀਂ ਗੱਲ ਕਰ ਰਹੇ employment law ਬਾਰੇ law in a workplace ਜਿਹੜੇ ਲੋਕ ਫੈਕਟਰੀਆਂ 'ਚ ਕੰਮ ਕਰਦੇ ਆ ਜਿਹੜੇ ਉਹਨਾਂ ਨੂੰ ਪ੍ਰੋਬਲਮਾਂ ਪੈਂਦੀਆਂ ਕੰਮ ਤੇ ਤੇ ਕੀ ਕਰਨਾ ਚਾਹੀਦਾ ਕੀ ਨਹੀਂ ਉਹਨਾਂ ਦਾ ਹੱਲ ਕੀ ਆ ਜੇ ਕਿਸੇ ਨੂੰ ਗਲਤ ਤਰੀਕੇ ਨਾਲ ਸੈਕ ਕੀਤਾ ਹੋਵੇ ਜਾਂ ਕੋਈ ਬੰਦਾ ਹਰਾਸਮੈਂਟ ਹੋਇਆ ਹੋਵੇ ਕੰਮ ਤੇ ਜੇ ਸੋਚ ਕੇ ਨਜਾਇਜ਼ ਮੈਨੂੰ ਕੋਈ ਕਹਿ ਰਿਹਾ ਉਹਨਾਂ ਬਾਰੇ ਅਸੀਂ ਗੱਲ ਕਰ ਰਹੇ ਹਾਂ it's a good topic for the youngsters I suppose and the professionals because a lot of people do have problems at work.
Oh, absolutely. I mean, you know and I know, we all live in big extended families, lots of people do different types of jobs, have different types of pressures. And people think, keep my head down, do the job. But the law says you have rights and you should exercise them. But equally, if you're an employer, you've got a factory or you've got a shop, you have rights as well. You can't be lumbered with someone who doesn't want to work. You can't be lumbered.
I mean, say ਜੇ ਤੁਸੀਂ ਕਿਸ ਨੂੰ ਕੰਮ ਤੇ ਰੱਖ ਲਿਆ, right? ਉਹ ਬੰਦਾ ਕੰਮ ਹੀ ਨਹੀਂ ਕਰਦਾ। ਉਹ ਸੋਚਦਾ ਮੈਂ ਤਾਂ ਬੈਠੂਗਾ ਇੱਥੇ ਮੈਨੂੰ ਪੇ ਮਿਲੀ ਜਾਣ। ਇਹ ਮੇਰੇ ਨਿਆਣੇ ਨੂੰ ਪਾਲੀ ਜਾਵੇ ਵਧੀਆ। I mean, ਇਹ ਤਾਂ who's an employer ਉਹਦੀ ਤਾਂ ਕਬੀਲਦਾਰੀ ਵੱਧ ਗਈ ਇੱਕ ਤਾਂ ਆਪਣੇ ਨਿਆਣਿਆਂ ਨੂੰ ਪਾਲੋ ਦੂਜਾ ਲੇਜ਼ੀ ਬੰਦੇ ਦੇ ਵੀ ਪਾਲੋ so it seems a bit harsh doesn't it?
Well, I don't know about harsh because that's subjective. It depends on where you're coming from in terms of point of view. But the key thing is that if someone hasn't been working, this is one of the, I don't know if it's a good thing or a bad thing. For me, I think it's bad. But you have no employment rights until you've worked for a year. You have to have 1 year continuous service with that individual.
Okay, so khatra dependa when an employee is over a year old.
Yes, because before then you can be asked to leave. You have no.
So saal de vich you can say anything to your employer, but you can say to your employee, "Chalo bhai, I notice par jao."
That's it. And
they can't bring a claim against you.
There's no recourse. No recourse. You can have a recourse for breach of contract. There, you can go to the county court, but in essence, in employment tribunals, you have to work for a year. If you haven't worked for a year, you've got no.
So you develop real rights after a year.
Yes, absolutely.
That's for dismissals.
Yeah, and breaches of contract as well. And redundancies, you have to be there for 2 years before you can get those kind of rights. So you work for a factory, they're going to close it down, and you don't get anything, but you've worked there for 2.5 years. That's wrong. You now have a claim because they're even there when they want to make you redundant because they're going bust. They have to follow the rules.
ਕਈ ਵਾਰੀ ਇਹ ਤੁਸੀਂ ਫੈਕਟਰੀ 'ਚ ਕੰਮ ਕਰਦੇ ਹੋ, you work in a factory or something, and ਤੁਹਾਡੀ ਮੈਨੇਜਰ ਨਾਲ ਨਹੀਂ ਬਣਦੀ, ਜਾਂ ਮੈਨੇਜਰ ਤੁਹਾਨੂੰ ਜਾਣ ਕੇ ਤੰਗ ਕਰੀ ਜਾਂਦੇ ਆ, treat ਨਹੀਂ ਕਰਦੇ fairly like all the other employees, or you get picked out, and you get victimized to an extent.
Yeah.
So what's your recourse in them sort of things?
The power you have then under harassment and victimization is far greater, far greater, because the others are sort of breaches of contract. So had I not been picked on, or had I not resigned, my salary would have been X. But you get extra for your harassment and for your victimization, sexual harassment, or based on your race, gender, colour, whatever you want, religion, you get extra.
Right.
But it's slightly complicated, which is why you need people like us to sort of run you through it.
It is a bit of a minefield, isn't it? It's not something you really want to be doing on your own.
No, absolutely not. There is a minefield, because if you don't follow procedure, that renders your claim nil, null, void, whatever you want to call it. In the actual fact, there's more problems in people working in offices than there is people working in factories, because factories are sort of male orientated.
Not in Birmingham, they're not.
They tend to be one gender. Well, they tend to be one gender orientated, so the dynamics are slightly different. But in offices, it's a completely different beast, and that's where you get actually more problems than you do in your.
Give me some examples of where people being like victimized, just like or they can face victimization in the workplace.
Well, you've got situations where you're in a team working in an office, you're all professionals, let's say, but for some reason your work, it's been questioned, the standard of it's been questioned, but nobody else's is, yet you're all doing the same job, you're all in the same pay grade, but only yours is, and you're working to everybody else's sort of standard. That's the kind of complaint you can bring up and say, well, hold on, that's fine. You're saying my work isn't up to standard. I haven't got a problem with that. You're telling me I've got to do A, B, C, but I'm only doing exactly what everybody else is doing on this team or on this floor or in this factory. Why are my work standards being questioned and no one else's? And that's where you can raise questions.
Okay, so ਜੇ ਤੁਹਾਨੂੰ constantly pick out ਕੀਤਾ ਜਾਂਦਾ ਹੈ ਤਾਂ ਬਾਕੀ ਸਾਰਿਆਂ ਦਾ ਕੰਮ ਵੀ ਉਸ standard ਦਾ ਹੈ, and you feel you're getting picked on, so you have a recourse there.
Absolutely. You don't have to leave the workplace, but sometimes 9 times out of 10 that the harassment or the questioning of your work is so bad you've got no choice but to resign.
ਕਈ ਵਾਰੀ ਹਾਲਾਤ ਇਦਾਂ ਦੇ ਬਣਾਏ ਜਾਂਦੇ ਆ ਤੇ ਤੁਹਾਨੂੰ resign ਕਰਨਾ ਪੈਂਦਾ. It's like they force you into a corner to make you resign, right?
Yeah, that's what they do.
Right. So what should a person do then? Or if someone who's become so unhappy that ਹੁਣ ਉੱਥੇ ਕੰਮ ਥੋੜੀ ਕਰਨ ਜਾਂਦੇ ਜਿੱਥੇ ਬੰਦਾ ਰੋਜ਼ ਹੁਣ sad ਹੋਵੇ, ਬੰਦਾ ਵੀ ਥੋੜੀ ਚਾਹੁੰਦਾ ਕਿ ਮਾਹੌਲ ਅੱਛਾ ਹੋਵੇ. So if they make it such a situation that you have to resign, have you got recourse then?
You have. There are lots of situations where you work somewhere, you don't get on with your manager, or you don't get on with someone else, and your manager isn't dealing with that other person, but day in, day out, you can't cope. So you've got to make a complaint. You've got to let the managers know. And whilst that's happening, they're still chipping away. You then left with a decision. And a lot of employers just leave it in the hope that you do resign and just go. And a lot of employers hope, and does happen, that once you resign and go, you're not going to make a complaint. You're just going to go somewhere else. But so that's why people should realise, well, if I'm forced to resign, it's called constructive dismissal. I now have a claim against my employer because it's wrong.
Right, okay. And in these claims, what do you have to prove?
Very little, to be honest.
No?
Yeah, the standard isn't massive, but it depends on what the complaint is. So in terms of sexual harassment, in actual fact, in most cases, what you've got to show is called a hypothetical character. That if a person like you was in the same position, if it's a sex case, a man, would he have been subjected to the same treatment had he been a man?
Okay.
If the answer is yes, you haven't got much of a case. But if the answer is no, then you have got a massive case. And it goes for victimisation, where there's the only woman in the office working amongst a lot of men, and she's subject to little remarks.
Yeah.
You know, like
You always hear these things in the news, like tribunals, that Flanna was called this, or an email went round saying this.
Well, they deliberately put things on a high shelf, knowing that you're the woman. You're going to be 9 times out of 10, you're going to be the smallest person there. You can't reach it, and that's deliberate. But if it was a man, would he suffer the same? And the answer most probably is no. So that's the kind of harassment that people get, and that's how it forms.
What about employers? Yeah, if someone takes them to court over their claims and all that, then how do they go about defending themselves?
Again, they have to come to people like myself. The thing about employment tribunals, you've got to understand, doesn't work like a normal court.
Right.
In that whatever culture you incur in going to court, that's your culture, and their culture is their culture. Unless your behaviour in court was so bad, you didn't provide evidence, blah blah blah.
So it's not like a civil case, really, where ਜਿਹੜਾ ਬੰਦਾ ਹਾਰ ਜਾਂਦਾ ਉਹਨੂੰ ਦੂਜੇ ਪਾਸੇ ਦੀ ਕਾਸਟ ਨਹੀਂ ਪੈਂਦੀ ਆ ਉਹ ਨਹੀਂ ਹੈ ਨਾ
For wrongful dismissal, which is a breach of contract claims, you go to the county court. There you can, but 9 times out of 10 the claims are unfair dismissal, constructive dismissal. You do those in employment tribunal, because you have to make the claim with the employment tribunal within 3 months less 1 day. You have to submit that, and they work completely differently.
If you've been sacked, right? And how important then is it that you clear your name afterwards, or if you think you've been wrongly sacked?
It's extremely important you do that.
Why?
Well, simply because it has repercussions when you move on. Now, if you move on, the first question they're going to ask is, why did you leave your other place? They may ask for a reference, but one of the essential questions is, why did you leave? If you say, well,
I got the sack.
I got the sack. You are not going to get a job anywhere.
Well, mate, yeah,
that's it. But if you go to the employment tribunal, you can clear your name, and as part of the deal at the end, you can say, well, I want a good reference, and I can say I resigned, or blah blah blah. Mutually convenient reasons we parted company, whatever. We don't have to say you're sacked.
Do you have to go to court to get justice, or can you try and sort it out with the employers?
You can try and sort it out with the employers. If you're unrepresented, you can go via ACAS, but all ACAS do is you say, I want £30,000, and all they'll do is phone the other party and say he wants 30,000. They'll then say, no, he can't, and then ring you and say, no, you can't have 30,000. That's all ACAS.
They just give messages to each other.
That's all it is.
Don't they mediate?
No. They can't give you any legal advice, no nothing. So that's how that works.
Right.
They're conciliatory and that kind of service, but they're limited as to what they can do. Whereas with a solicitor who knows what he's doing, he can negotiate on your behalf.
Well, how long do these tribunals go on for?
It depends on the seriousness. Most, 9 times out of 10 a day, the most I've ever done, I think it's 4 days, but very, very extreme.
No, from start to finish?
Oh, you're looking at about 3 months.
3 months?
3-4 months, yeah, that's it.
Okay.
It depends where you lodge the...
so different courts and different...
Yeah, because they might have a different sort of waiting list. But essentially that's about that long.
Right, okay. What other pitfalls are there during work that you need to be careful of? If you're an employee and an employer?
Well, I think with an employer, it's far more onerous. Make sure that when you write your contracts, you know what the contract says. It's no good.
If you're an employer?
Yeah, if you're an employer. So there's no point saying, here's your contract, and you don't even know what you've let yourself in. Yeah, and you need to know what your rights are. And that's where, again, you put in a lawyer and say, look, I want you to give me advice. What should be in the contract, minimum, if that's what you want. And then make sure you understand it. Otherwise, give it to the lawyer and say, right, this is what this means. You've got to know what your obligations are.
Once a contract's signed, do the terms of that contract dictate? Because that's the contract of the law which they the agreement
Not necessarily.
Because employment is different, yeah?
Yeah, because you may say in your contract you only get 10 days holiday.
Yeah, right, yeah. I might say to my employee that I can get rid of you whenever with 1 day's notice.
Yeah, and we know EU law and UK law doesn't allow you to do that. There's a minimum number of days that you can have holiday set by the EU. There's a minimum number of hours that, like 48 working week, you need to make sure that the employee and the employer, they both understand minimum wage as well, for different age groups. You've got to know all of that. Any breach of that.
So you can't just say, right, sign then job mil gayi.
And you have to give people either a document, and it can be called whatever you want to call it. Right. It's under Section 1 of the Employment Rights Act, or a contract. But you have to give the employee that within 2 months. If you don't, you leave yourself breach of contract and liable to the employment tribunal.
Okay. Now, so that's for employers, yeah? What else do employers need to do? They shouldn't get hot-headed, should they?
Absolutely not. Absolutely.
ਜੇ ਕੋਈ employee ਪੁੱਠਾ ਕੰਮ ਕਰਦਾ ਤਾਂ ਇਹ ਨਹੀਂ ਕਿ ਗੁੱਸਾ ਆ ਕੇ ਤੁਸੀਂ ਉਹਦੇ ਕੰਮ ਤੇ ਛੱਡ ਦਿਓ ਦੋ ਜਾਂ ਕੋਈ ਨਿਕਲ ਇੱਥੋਂ ਚਾਬੀਆਂ ਫਰਾਮ ਹੋਈਆਂ ਜੋ ਵੀ ਆ ਇਹ ਵੀ ਥੋੜਾ you have to do it by system ਦੇ ਹਿਸਾਬ ਨਾਲ ਜਾਂ ਕਾਨੂੰਨ ਬਣੇ ਹੋਆ.
You've got to try, I suppose. If you've got like a convenience store where you're going to have, I don't know, 5 or 6 people working there, give one of those a responsibility of looking after the staff, so if there's any issues they deal with it, so that there's a tier. They go to that manager, hasn't been dealt with, then they go to you and you resolve it. You should always try and resolve things, mediate, at the earliest opportunity, rather than leave yourself so wide open that you end up in a tribunal court. And it can be expensive.
What about if your employee karda inna bad that you got no other choice? Farz karo employee ne sara kam thoda puttha kar dita. Jo tusi kiha ji car green chahidi paint karti on laal paint kar diti. On पहिए भी लाते on सारा कुछ है खराब करके. In fact, it was working when it came in and so that he थोड़ा fraud करदा थोड़े नाल जाओ बिल्कुल जिद्दां तुसी उन्हें काम सकाले जे करना चाहिए उद्दां नहीं कीता. What does an employer do then?
Right, the employer's got to look at what it's cost them. Right. So if it's absolutely vital that shop should be red and not blue or whatever it is, or blue rather than red, then you've got to look at what the consequences are. But if the employees, he's got to be capable and competent at what he's doing. If they're not, you can say, well, look, it's not going to work. But what you have to do is give them a chance. Give them a chance and then say, right, I need you to do this by this week, that by that week. If you can't, then we're going to have to terminate the contract. But what you have to do, whatever it is you do, it has to be fair. So you have to give them a chance to redeem themselves, get things right finally.
Well, we're going to go to a break, honestly break, but after that we're going to talk a lot more. And you're going to tell us about ESOL as well.
Oh yes, ESOL.
Yeah. If anyone else wants to know about ESOL. But let's talk about more employment law, because I think I'm getting a lot of calls from a lot of people who are saying, yeah, probably this is a good topic because we're having trouble at work. And so can you help us go through it? So, ਅਸੀਂ ਜਾਨੇ ਬ੍ਰੇਕ ਵਾਲ ਤੇ ਤੁਹਾਡਾ ਗੱਲ ਕਰਦੇ ਸੀ ਬ੍ਰੇਕ ਤੋਂ ਬਾਅਦ.
ਮੈਂ ਤੁਹਾਡਾ ਹਰਜਾਪ ਤੇ ਹਰੇਕ ਮੰਡੇ 7 ਵਜੇ ਤੁਸੀਂ ਤੇ ਮੈਂ ਆਪਸ ਵਿੱਚ ਗੱਲਾਂ ਕਰਾਂਗੇ ਸਾਡੀ ਕਮਿਊਨਿਟੀ ਦੀਆਂ, ਸਾਡੇ ਬੱਚਿਆਂ ਦੀਆਂ, ਸਾਡੇ ਬਾਹਰ ਰਹਿੰਦੇ NRIਆਂ ਦੀਆਂ, ਸਾਡੇ ਦੇਸ਼ ਦੀਆਂ ਤੇ ਜੋ ਅੱਜ ਕੱਲ ਦੇ ਇਸ਼ੂ ਹੈਗੇ ਸਾਨੂੰ ਅਫੈਕਟ ਕਰਦੇ ਉਹਨਾਂ ਦੀਆਂ. So let's talk with Harjap.